Hello there, my dear friends. We're now on our second round of suggested answers to the November 2022 bar examination, this time on criminal law. I have included all the questions except the matter of showing an example of an information regarding bouncing check. I don't think that that is something complicated and it is required only for purposes of legal forms. So without much ado, I welcome you now to the suggested answers to criminal law. Some of you already know my qualifications, so we'll skip with that. We'll go to the first navigational page, we call it, to show what we're given in criminal law in the 2022 bar examination. There are modules that cover the following subject matter in criminal law. There were questions on persons, on felonies, on chastity and child abuse, on prohibited drugs, on cybercrime, and graft and corruption. We will go to this again, and we go to the crimes against persons as covered by some questions. Then we go back to this, we move to felonies, and so on. So let us now move to the problem given on persons. Problem number one deals with homicide and self-defense. And the problem reads, Police Officer John ran after Randy, who had just killed Willie, in John's presence. John fired at Randy in an attempt to stop him in his tracks. In response, Randy fired back at John, hitting him. John was seriously wounded but survived due to timely medical assistance. Randy was then charged with frustrated homicide. During the trial, Randy claimed self-defense. Is Randy's claim of self-defense tenable? Explain. Let me just see whether I can arrange this to allow you to see a better view. And so our suggested answer would be as follows. No, Randy's self-defense is not tenable. The requirements to invoke self-defense are 1. Unlawful aggression, reasonable necessity of the means employed to present or repel the aggression, and provocation. In the case of unlawful aggression, the police officer John was fulfilling his lawful duty. He cannot be committing unlawful aggression against Randy. Reasonable necessity of the means employed to prevent or repel aggression. Randy shooting at an arresting police officer is not a reasonable means to defend oneself after committing a felony. As the criminal offender, he should have surrendered to John. And that on the area of no provocation, Randy's killing of Willie in police officer John's presence is enough provocation for John to perform his lawful duty by arresting Randy. This was demonstrated in 2005 in the case of Kabanlig versus Sandigan Bayan, and much earlier in 1922 in the case of People versus De Lima. In the area of felonies, hold on for a while, there is a second problem involving persons, and this time it is on homicide and involving treachery, which is a qualifying aggravating circumstance in the area of moving homicide to murder. The problem reads, Moe, Curly, and Larry were drinking and singing inside a karaoke bar when suddenly Buboy entered the bar and without warning immediately shot all three of them using a caliber 45 pistol. Thereafter, Buboy ran out of the bar to escape. Moy, Curly, and Larry died instantly due to gunshot wounds in their heads and bodies. With the help of eyewitnesses, Buboy was arrested. After inquest, the prosecutor charged Buboy with 3 counts of homicide. Do you agree with the charge of homicide against Buboy? Explain. Our answer, I agree that Buboy is to be charged with homicide. He did not commit murder. There was no treachery as a qualifying aggravating circumstance. Buboy did not plan the shooting to intentionally place the victims where they had no chance to fight or retreat. Buboy's shooting was not designed to make it impossible or hard for them to defend themselves or to retaliate. This was the decision of the Supreme Court in the case of People versus Gonza, a November 11, 2003 decision. Now, moving to, hold on for a while, we now are supposed to be handling, we're back to persons, and it appears that there were only 2 problems on persons given in the 2022 bar examination. We now therefore move to the issue of felonies. The problem that was given on felonies runs this way. And this was problem number 3, involving the concept of praeter intentionem versus accident. Michael was driving along the highway when he executed a prohibited U-turn. George, a police officer, accosted Michael for the traffic violation. A verbal argument ensued between them. George suddenly drew his service firearm and pointed it at Michael. George ordered Michael to alight from his car, which the latter obeyed. George then handcuffed Michael and pinned his head and body against the pavement until he could no longer breathe. Michael died. Charged with homicide, George interposed the exempting circumstance of accident as a defense. If you were the judge, how would you resolve George's defense? Explain briefly. As the judge, I would proceed with George's prosecution because his exempting circumstance of accident cannot be valid. The required circumstance to set up accident would only be tested in the following 4 categories. Number 1, the one setting up the accident as an exempting circumstance should be performing a lawful act. And he should be performing that act with due care, and along the way, he caused injury by mere accident, and there was no fault or intention of causing the injury. The attending facts indicate that George drew his firearm, handcuffed Michael, pinned his head and body against the pavement until he could no longer breathe and died. Now, the attending circumstances would be like this. When George drew his firearm, that is not a lawful act. There was no need for him to draw his firearm. He was not even in danger of any assault against him by Michael. Second, he's spinning the head and body of Michael against the pavement is not with due care. That would be that could lead to consequences, and so that therefore that's exactly what happened. Third, the drawing of the firearm, the pinning the body against the pavement were deliberate acts and not fortuitous events. So the movement or the acts of George were really intentional and deliberate, and therefore it could not have led to an accident because he was intentionally doing those acts, and those were not fortuitous events. And so because there was death resulting to homicide, Michael's death is presumed to be with intent according to criminal law. The fourth topic on felonies has something to do with conspiracy and evident premeditation. The problem runs like this. Bernardo, a mayoralty candidate of Osram City, wanted to eliminate Yori, his political opponent. Yori announced his intention to run for mayor of the same city. A month before the filing of candidacy, Bernardo and Benjamin met at a hotel and discussed their plan to kill Yori on the day when he would file a certificate of candidacy. Based on their agreement, Bernardo would provide the guns and the money, while Benjamin would provide the personnel to cordon off all roads leading to the Comelec local office. On the day of the execution of the plan, however, Benjamin flew to Manila to avoid being involved in the planned killing of Yori. Bernardo, determined to kill Yori, convened his own armed group and laid out a new plan to kill Yori, and in accordance with it, his armed group patrolled all the roads leading to the Comelec local office. Bernardo remained in his house and monitored the execution of the plan from there. As soon as Yori and his supporters passed by the main road at around 2 p.m., Bernardo's armed group opened fire at them. Yori was unharmed as he was inside the bulletproof vehicle, but 10 of his supporters were killed. Bernardo, the members of his armed group, and Benjamin were later charged with 10 counts of murder for the death of Yori's supporters and 1 count of attempted murder of Yori. Discuss the criminal liability for the crimes charged against each of the following: Bernardo, the members of the Bernardo's armed group, and Benjamin. Explain briefly. This would be covering the areas of conspiracy and evident premeditation. In the case of Bernardo, he is a principal by inducement for murder, 10 counts, and attempted murder, 1 count, in conspiracy with the 10 armed men. Bernardo has qualifying aggravating circumstance alone of evident premeditation and committed the murder with a band of more than 3 assailants. The 10 armed men are principals by direct participation for murder and attempted murder for 1 count in conspiracy with Bernardo. The 10 armed men have qualifying aggravating circumstance in committing murder with a band of more than 3 assailants. And there can be also an issue where because they were acting in conspiracy, the act of one is the act of all. Therefore, the evident premeditation of Bernardo would be attributed likewise to them. In the case of Benjamin, he has no criminal liability for not participating in the execution of the offense. The fact that he discussed with Bernardo the assassination, but at the time that there was a gap in time between the planning and the execution, Benjamin changed his mind and therefore did not participate in the execution of the plan. He therefore will have no criminal liability. This particular case is lifted from the case of People versus Peralta, an October 1968 decision involving likewise conspiracy and evident premeditation. Now, there is a problem on stages of execution comparing consummated versus attempted parricide. The problem number 5 runs. A police officer responded to a disturbance call at around 1:30 p.m. in an apartment in Quezon City. Upon his arrival, the police officer encountered Sisa stabbing her 1-year-old child with a kitchen knife. The police officer grabbed Sisa and the latter threw the knife on the floor. Sisa was immediately taken into custody. Despite suffering multiple stab wounds on her back, the child survived. During the trial, Sisa insisted that she can only be held liable for attempted parricide because she voluntarily desisted when she threw down the knife. Is Sisa's contention tenable? Explain briefly. No, Sisa's contention is not tenable. The first stab wound completed the elements of execution. Frustrated parricide was the offense committed because the child did not die for a cause independent of the offending mother's will. Without the mother throwing the knife, that could have started another process of parricide different from the initial frustrated offense. This is taken from Article 6 of the Revised Penal Code and illustrated in the case of Valenzuela versus People in June of 2007. Problem number 6 had something to do with complex crime involving robbery with homicide. Anna and Barbara, while working inside their sari-sari store, saw Javier and George robbing an elderly woman of her purse and brutally beating her to death. Anna and Barbara immediately ran outside, and when they tried to help the elderly woman, Javier and George stabbed both of them. Thereafter, Javier and George ran away with the elderly woman's purse. Anna suffered one stab wound which punctured her lung, but she survived due to timely medical assistance. Barbara, however, died as a result of 9 stab wounds, one of which pierced her spleen. If you were the prosecutor, what crime or crimes will you file against Javier and George for the death of the elderly woman, the death of Barbara, and the injury sustained by Anna? Explain briefly. As the prosecutor, I shall file an information for the complex crime of robbery with homicide. For the number 1, elderly woman's death, homicide, first count. Barbara's death, homicide, second count, and Anna, frustrated homicide. In a special complex crime of robbery with homicide, the offense is an individual felony with a specific penalty in the Revised Penal Code. It includes the elements of consummated homicide on 2 counts and frustrated homicide, all included in the information. This is in accordance with Article 294, Paragraph 1 of the Revised Penal Code and decided in the case of People versus Casabuena, a June 2020 decision. Problem number 7 involved another complex crime of murder and unlawful possession of unlicensed firearm in murder. Jesusa, a mayoralty candidate of the municipality of Jaén, Nueva Ecija, during the 2019 local elections, was ambushed and gunned down by Judas, a gun for hire. Judas was arrested at the Comelec checkpoint just after the incident. The firearm he used, a baby Armalite, was verified to be without any license. During the interrogation, Judas admitted that Poncio, the rival minority candidate of Jesusa, paid him 1 million to assassinate Jesusa. Due to Judas' admission, coupled with the sworn statement of an eyewitness, the prosecution filed 2 information, one for murder and one for illegal possession of firearms against both Judas and Poncio. Do you agree with the prosecutor's charges against Judas and Poncio? Explain briefly. I agree with the prosecutor's information for murder with price or consideration as the qualifying, aggravating circumstance. Then another information for the offense of illegal possession of unlicensed firearm aggravated by its use in committing murder. The illegal possession case does not absorb the offense of murder, nor murder absorb the illegal possession offense. The 2 offenses must be prosecuted separately. They are not in the revised penal code as a complex crime, and this was decided in May 1992 in the case of People versus Scaling. Number 8 involves in the impossible crime of a stolen unfunded check. Jenny obtained a fire insurance from YG Insurance Company. In payment of the policy, she issued a post-dated check payable to cash in the amount of 15,000 pesos, which was handed to Lisa, YG's sales agent. Lisa did not remit the check to YG. Instead, Lisa deposited it in her husband's bank account, but the check was dishonored for having been drawn from a closed account. What crime, if any, was committed by Lisa, and if there was any, what is its prescribed penalty? Explain briefly. Our suggested answer, Lisa committed an impossible crime punishable with 6 months of arresto mayor. Lisa performed the acts of consummated qualified theft, a crime against property. Her unlawfully taking the check for mega form is her intent to gain or be unjustly enriched. She would have received the value of the check, which was not hers, if it did not bounce. The unfunded check prevented the theft. Said check Lisa unlawfully took turned out to be worthless. This is consistent with Articles 4, Paragraph 2 and 59 of the Revised Penal Code, and also decided in the case of Jacinto versus People, decided in July 2009, and Intod versus Court of Appeals, decided in October of 1992. Bouncing check BP22 information. This one requires us to drop the appropriate information, complete with caption and title charging Bob for violation of BP22. We will skip this because this is just a standard legal form for the preparation of information, but what is important is to indicate the elements of BP22. And the last problem on felonies is problem number 11, another complex crime involving reckless imprudence resulting to homicide, serious physical injuries, and damage to property. On May 15, 2013, at around 3 a.m., Lucy, Mary, and Raphael were on board a passenger jeepney, with Raphael behind the wheel. They were traversing the highway on the southbound lane. Meanwhile, a Virgin bus driven by Kiko was traveling along the northbound lane. Kiko overtook the vehicle in front of Wim, which caused him to occupy the opposite lane where the jeepney was on. With the Virgin bus traveling at a high speed, Raphael tried to avoid the collision but failed. The bus hit the jeepney, which resulted in Raphael's death, serious physical injuries to Lucy and Mary, and extensive damage to the jeepney amounting to 500,000. The public prosecutor filed two informations charging Kiko for two separate offenses. One, reckless imprudence resulting in serious physical injuries for the injuries suffered by the passengers, and two, reckless imprudence resulting in homicide and damage to property for Raphael's death and the damage to the jeepney. Is the public prosecutor correct? Explain briefly. No, the prosecutor is not correct. The offense is the complex crime of reckless imprudence resulting to homicide, serious physical injuries, and damage to property. The single act of reckless imprudence or criminal negligence resulted into the felonies of Raphael's death, the serious physical injuries of Lucy and Mary, and the damage to the passenger jeepney. The filing and possible conviction in the two separate information can amount to double jeopardy. This is similar to the case of Diap versus Sendiong, decided in January of 2009, and Dumayag versus People, decided in November of 2012. Those were the problems, quite relatively long, involving felonies in Book 1 of the Revised Penal Code. Let us now move on to chastity and child abuse. Child abuse acts, lascivious acts with child consent. Madam X, with the promise of money and without the use of force, intimidation, or threat, enticed Zia, a 15-year-old, to engage in oral sex by allowing Madam X to lick Leah's vagina. Zia consented because she needed the money. What crime, if any, was committed by Madam X? Explain briefly. Madam X committed no crime. An individual who engages in lascivious acts with a child, at least 12 and under 13 years of age, with her consent, is not punishable under the law on the protection of children and the related Supreme Court decisions, no? Especially Bangayan versus People, a September 2020 decided case. Chastity and child abuse. Problem number 13 in the bar examination, Joe Ben, a school principal, called high school students Paula and Gina, both 15 years old, to the faculty room regarding the sexual text message circulating around the campus which made reference to Joe Ben's daughter. In front of teachers and some students, Joe Ben shouted at Paula and Gina, asking them who sent the said text message. Joe Ben also threatened to sue them and said, "Siguro naiinggit kayo sa anak ko kasi maganda siya, matalino at mayaman. Sabihin nyo kasi sa mga magulang nyo, magsumikap sila para maging mayaman din kayo. Di yung tatamad-tamad." Joe Ben raised her middle finger in front of Paula and Gina saying, "Mga burikak." War. Later that day, Paula and Gina narrated the incident to their parents and said that they were ashamed of going back to school. Is Joe Ben guilty of violating Section 10, Paragraph A of Republic Act number 7610 for other acts of child abuse? Explain briefly. No, Joben did not commit child abuse to violate Section 10A of Republic Act 7610. Child abuse is the act by deeds or words to debase, degrade, or demean the intrinsic worth and dignity of a child as a human being. Joben did not have intention to debase the worth and dignity of Paula and Jima. She was shouting at and berating them solely as an angry mother of her offended daughter. And this is decided in the case of Escolano versus People, a December 2010 decision in relation to Republic Act 7610 on special protection of children against abuse, exploitation, and discrimination. Moving now to the next case, which is prohibited drugs. This is a very interesting question, and I'm sure many would have had some difficulty in answering this. This is problem number 12, and I was smiling when I was trying to analyze this. Reading the problem now. Sometime in 2012, while police officers were conducting a foot patrol in connection with the report of rampant illegal activities in the area, Police Officer Pepe saw Raul inside the small shanty holding a disposable syringe. Being a police officer for almost 15 years and having previously made more than 10 arrests involving possession of drug paraphernalia, Pepe entered through the open door of Raul's shanty and arrested him. Inside the shanty, 23 more pieces of disposable syringes and empty ampules were seized from Raul. Pepe immediately marked the seized items, took photographs thereof, and conducted an inventory in the presence of Raul, a barangay kagawad, a representative from the Department of Justice, DOJ, and a media practitioner. The seized items were turned over to the evidence custodian who kept them in a sealed container in the police station. During the trial of Raul for the crime of illegal possession of drug paraphernalia, Police Officer Pepe, the sole witness for the prosecution, testified as narrated above, after which the prosecution rested its case. The defense did not present any evidence. If you were the judge, would you convict or acquit Raul for the crime charged? Explain briefly. My suggested answer: as the judge, I shall acquit Raul for the prosecution's failure to establish that the syringes and empty ampules have traces of any prohibited drugs. There is no laboratory test to establish the use of said paraphernalia in prohibited drugs. The constitutional presumption of innocence with no proof beyond reasonable doubt will merit the acquittal. Okay, and so this was the case of Evelyn Abadines Cuico versus People in December of 2020. Very, very recent. And so that is the single problem in prohibited drugs. So just the fact that you have a syringe or you have ampules, but they're empty, cannot immediately be an incriminating evidence unless those paraphernalia were tested and positive to be connected to prohibited drugs. Napakaganda, napakapino, no? The presumption of innocence under the Constitution will come in. Now, on cybercrime. And this is on cyber libel. This is problem number 10 in the bar examination. During the 2022 national elections, Byrne posted on her Facebook page a statement that Alfredo, an incumbent mayor vying for re-election, has a pending corruption case with the Sangguniang Bayan for pocketing 20 million of public funds under his custody. Charina, Byrne's friend, saw the post and commented online stating, "Bye, true yan. Alfredo is so corrupt. Marami ding binabahay yan. Sugarol pa." Donabel, also Byrne's friend, reacted to Ben's post by clicking the like button. Another person, Justine, who is a stranger to Byrne and her friends, but who claims to be a crusader for good governance, came across the said post. Finding it relevant to her advocacy and crusade, Justine shared the link to Byrne's post on her Twitter account. Who among Byrne, Charina, Donabel, and Justine, if any, are liable for the crime of cyber libel? Explain briefly. Charina is liable for cyber libel on her online Facebook comment of "Alfredo is so corrupt, marami ding binabahay yan, sugarol pa." Her public and malicious imputation of a crime, corrupt, and vice, binabahay and sugarol, dishonors Alfredo. Byrne, Donabel, and Justine posted no comment to dishonor Alfredo with public and malicious imputation of a crime, a vice, a defect, or any act, omission, condition, status, or circumstance. I would take exception that these people were involved in any offense, either as a, what we call this, as a principal, neither as an accomplice or an accessory after the fact. They were not making any pronouncements the way Charina was making her comment. And finally, in the area of graft and corruption, the issue of grave misconduct in relation to the procurement law as contained in problem number 15 in the bar examination. In 2003, the province of Davao del Sur purchased 2 vehicles for the use of the governor and vice governor respectively. The purchase requests, which were all signed by Luis as then governor of the province, requested for the acquisition of 1 unit of Ford Ranger XLT 4x4 and 1 unit of Toyota Hilux 4x4. The procurement of the subject vehicles did not undergo competitive bidding as it was effected through direct purchase. The mode of procurement was approved by the members of the Bids and Awards Committee of the province. The 2 vehicles were delivered to the provincial government, and after inspection and acceptance by the concerned officials, payments were issued to the suppliers. Subsequently, a complaint was filed by a concerned citizen before the Office of the Ombudsman Mindanao, claiming that the purchase of the provincial government violated the procurement law. The OMB, after due investigation, verified that the provincial government did not comply with the required procedure of the procurement law. Based on this finding, the Office of the Ombudsman of Mindanao filed with the Sandigan Bayan an information against Luis and the members of the BAC for violation of Section 3, Paragraph E of Republic Act Number 3019. The Sandigan Bayan found Luis and the members of the BAC guilty on the sole reason that violation of the procurement law constitutes evident bad faith and manifest partiality on the part of the accused. Is the Sandigan Bayan correct? Our suggested answer, no. The Sandigan Bayan should have found Luis and BAC members as having committed grave misconduct and gross neglect of duty for violating the procurement law concerning the mandated competitive bidding. It is not only an issue of evident bad faith. it is grave misconduct and gross neglect of duty. And this was based on a decided case, Ombudsman Mindanao versus Martel, a March 2017 decision. And so, ladies and gentlemen, that comprises the problems given in criminal law. And if you notice, there are certain questions that are not very easy, like the last one where it involves procurement, which is not a normal subject matter that you would know unless you have really come across that particular law. The others are reasonably tough, and it would demand that the law student taking that examination must have a strong foundation in criminal law. And criminal law is very important because for new lawyers, they would probably be confronted with criminal law when they join the public attorney's office, when they join the practice of law, because many of the cases that they will be encountering would be in criminal law. So thank you very much for watching the second round. I had my first round in commercial law earlier, and this is now the second round on criminal law. What is coming up is labor law, another interesting one. Before we proceed to political law and ultimately to procedural law that is coming in. Maraming pong salamat and thank you for allowing me to be part of this particular very wonderful exercise.